can hear the speakers, because otherwise there's background noise. Raise your hand for questions. Everybody will have a chance to ask questions. This is our third series in the competition seminars, competition markets. We had Eric Manis. I hope you saw that. Eric Manis was one of the people who set up the Competition Commission as a World Bank team member. The structure of the seminar is very simple. I'll explain it to you, but please focus on the cartoons, which we show every webinar. We are led by donors. They tell us what to do and we follow it. And this is what happened in the Competition Commission too, but we'll get to that later. We have got a great panel. We've got Madam Shaista Bano, who's the acting chairperson of the Competition Commission. We have Rahat Kunan, who was the former chairperson of the Competition Commission. We have Malia Bangash, who used to be a member, in fact, a founding member of the CCP. And we have got Ikramul Haq, another founding member of the CCP, who's a well-known competition lawyer as well. So you've got...
Please use the word Qureshi as well for my last name, because there are two other Ikrams, you know, in CCP at this point of time.
Okay.
Just to distinguish it, yes.
So you are Ikramul Haq Qureshi?
Right, sir.
Okay, great. Ikramul Haq Qureshi ji.
Yes.
So we've got Ikramul Haq Qureshi Sahab too. We've got 4 people. We've got great expertise. Now on the structure of the webinar, we will ask you some questions and you will be free to answer them. The seminar is not supposed to be on Competition Commission only. We are talking about markets too. Ultimately, the whole purpose of setting up the Competition Commission was to have proper markets. To us economists, the market is the most important thing, because ultimately we are trying to create a competitive environment where people can have a race and win some cups, which means profits or which means going somewhere. Unfortunately, what we've seen is that what we needed, and this is what the World Bank does best, or donors do best, and this is where we finished the last webinar, and I asked this of our friend Eric Manis too. I think we needed deregulation. We still need deregulation. But what we got was a Competition Commission, which is way ahead of its time, which has added to our legal burdens, which has meant that we have now multiplied our cases, which has meant that our businesses are stifled under more legalese, under more law, and lawyers have become much more useful in the society, are raking it in. So how would you people, Madam Shaista Bano, bataiye, what is the reason for the Competition Commission? Why are we not deregulating? Why are we adding to competition law? And what is required in the market is extreme deregulation. What we've seen from our studies, and we've got lots of studies to show, that what we have is that the market doesn't work anywhere. I was checking your notices too, your policy whatever, notes or whatever. Every one of them is talking about how the government is interfering in markets. The government interferes in the sugar market, the government interferes in the wheat market, the government interferes in the automobile market. So essentially what we need is deregulation, not competition. Yet you people are doing competition, not deregulation. So how does this work? Please explain, madam. Shaista Bano Bibi. Ji. Ji, Shaista Bibi, boliye. You can unmute your mic and speak, please.
Thank you so much for inviting us here, and I particularly appreciate this initiative of initiating this debate on why competition is important and why our markets are not becoming competitive as we desire, and why there is no deregulation, why there rather less deregulation. So if we see, I would like to make a broad statement that although Competition Commission is very important player in ensuring competitive markets, but it is not the only player, particularly in case of Pakistan, where we have moved from a nationalized economy to a private sector economy. We were in the phase of transition. And initially, we can see that we achieved some good results in the form of increased growth in private sector, like in the telecom sector, in the banking sector. we saw a growth, number of players increased, and ultimately the competition started improving. I mean, the choices to the consumers started improving. There was investment, there was R&D, but with the weak implementation and rather with the regulation and with the government interventions, these markets could not flourish and could not become competitive. So the Competition Commission tried to play its role. We did a lot in the form of enforcement of law against these powerful players who were initially as the powerful public sector players, and they became the powerful private sector players after privatization. And we tried to intervene, especially in the telecom market, in every sector. We tried to intervene and we tried to break the cartels, and we tried against our enforcement actions against the abuse of dominant position by these dominant players. But as you know, and as it was debated in the previous webinar as well, that the courts, like the court cases, were a big hindrance in achieving our results. Secondly, at the policy level, we have not been very effective, like as you mentioned, that in every sector, whether it's agriculture, whether it's industry, there is a lot of government intervention. Through policy notes, we have tried to address the competition issues, like in the sugar sector, we issued policy notes. In the banking sector, in every sector, we have tried to issue policy notes and public opinions to address these issues. But still, I think at this point in time, there appears to be some seriousness from the government, because the government is taking now our court cases very seriously, and they are the Attorney General Office, who is representing the Federation. They are serious in pursuing our legal cases. In spite of the summer vacations, our cases are fixed in the Lahore High Court on day-to-day hearing basis, and they are serious in resolving those cases. So we see some kind of hope in the legal side as well. So on the policy side, we are trying to pursue our policy notes as well with the ministries and with the government bodies. But this is not an easy task because first we have to convince them the importance of competition and the importance of deregulation, and that is a very hard job. So at our level, we are trying our best. Let's see, in the near future, maybe we see some good results.
Okay, great, thank you. Rahat Bibi, aap bataiye, why do we have a competition commission and not a deregulation commission? Australia had a productivity commission and managed to deregulate their economy. Britain had deregulated the economy. We've got a heavily regulated economy as well as competition commission, which is acting like another regulator. Ji, Rahat Kunain. Rahat is not there. Is she gone? Okay. Mimi Bangish, can you take that up while I try and see if Rahat is there?
Certainly. So I think you've made a very good point, Dr. Saab, about the actual approach of what the competition law and the commission should be. Why do we have, the question was, why do we not have a productivity commission, or why don't we have something that encourages deregulation? I think that it's all quite intermingled. I think that competition law in itself is not really telling us what to do to be more competitive. It's prohibiting or it's preventing. It has a sort of a guideline for not being very competitive, and it's also a guideline for those who are not very competitive. So it's a competition guideline of sorts. I'm of the view, and in the early days when I was under the leadership of Dr. Khalid Mirza, Ms. Shaista was there with me as well, Ms. Rahat was there with me as well. When we were there, it was very clear that we would have a very facilitatory and very sort of a compliance-oriented approach for all the private sector. And we needed to have a very service orientation for the private sector to become more competitive and to take them along, which is why we had consultation, we had advocacy, and like Ms. Shaista just said, a lot of advocacy notes, which I was looking after the area of advocacy, were written, which were in those days taken quite seriously by the government, and hence they had an impact on the private sector. I would like to sort of say that ideally a competition commission and the mindset that we had was should create the environment that actually helps create a level playing field, and then helps in turn helps the people who are operating in that level playing field, which is small, medium, large enterprises of all sorts, flourish and grow, and so in fact increase competition. So the breaking, hence the breaking of cartels, the breaking of collusion, all of that is ideally supposed to create more competition. And what will that lead to? Greater efficiencies, and greater efficiencies per se are linked to greater productivity and this competitiveness and improvement in the business environment. So if we look at it holistically, it is, I think, Ms. Shaista also sort of touched upon it, and I think Mr. Khalid Mirza will also speak on. In its entirety, it's a very critical pillar to create those free markets and those efficient markets and those productive markets that we as economists, or we as players within the private sector would ideally want. Now, the question arises whether in Pakistan there is a tendency to compete. And in our experience, and I'm going to speak firsthand, when in the early days we used to advocate, when we went to seminars, we would have prominent people, advocacy seminars we would hold, say to us that, look, Chairman Saab and honorable members, how is it possible for us to not get together as an industry? Or obviously as an industry, we have to get together, we have to decide on prices, we have to lobby for our interests, we have to be in touch with each other. So what I'm trying to, which was quite funny, and we would laugh about it because they were so, it was a given, it was the norm to collude. And so it was really a very challenging environment to start in. But I think since then, what the Competition Commission has done, it has created an environment where people understand the importance of competition. I think collusion now, even if it is happening, perhaps it cannot be done so openly. I would like to say here that, looking at some of our past orders and some of the very good decisions that were taken, and Ms. Shaista again alluded to those, if those can be pursued in the courts and if some conclusions can be brought to them, I think it will impact very positively on the markets and the eventual purpose of competition, which is greater productivity and efficient markets, and what we believe in free markets would be achieved.
Ji, Qureshi Saab, your law that I've been briefly looking at seems to be quite expansive. It even gives you powers to raid places. It even gives you more or less police powers, which I find very strange. And the other thing is that I was on a recent webinar with people from Australia and India. It was a CUTS seminar, CUTS, which is a competitiveness body. And it is a bunch of lawyers who just want to establish competition councils everywhere to keep lawyers occupied. So how would you react to that, Qureshi Saab, since you're one of the people who set this up? Is the law too intrusive? Is it too regulatory? Does it believe that the market happens freely, or does it believe that the market has to be created through law? Qureshi Saab?
Thank you, sir. Thank you for the opportunity having me on this webinar. We have to stick with the agenda of the Competition Commission of Pakistan, which is provided in the Competition Act of 2010. Basically, it was promulgated as an ordinance when Khalid Mirza Sahab was the chairman in 2007, and then in 2010 when Rahat Konain Hassan was the chairperson, then it was promulgated as an act of the parliament. So I am of the view is that the purpose of the Competition Commission is to ensure free competition in the markets, in all the markets. All those markets which have been deregulated by the government. It is not the task or the job of the Competition Commission to deregulate some markets, So first of all, it is the deregulation, and then it comes the Competition Commission, Wherever in the first generation reforms or even in the second generation reforms, the government of Pakistan have deregulated various different markets like telecom markets and all banking markets and all other markets. And then, it is the Competition Commission to ensure the free competition and the protection of the consumers wherever there is an economic and commercial activity in those areas, and to ensure that there is no abuse of dominance, there is no cartelization, as all other speakers were saying, and also the advocacy and so on and so forth. The purpose of the Competition Commission is to see, where there are entry barriers, for example, or where there is an abuse of dominance, to ensure that to eliminate or at least to lessen those evils in the competition law, as I would say. Now, having said this, there could be many questions could be asked, regarding the Competition Commission. After the deregulation, there is privatization, and privatization commission was set up, and the purpose of the privatization commission is to effectively deregulate, all those segments in the markets, by giving out those companies and entities to the private sector. And then it comes the Competition Commission. All around the world, the competition commissions have almost same kind of a law. Maybe we can take the examples of EU or any other countries, including the India and all those countries. They have same competition law, and there is a common thread between all these, and the common thread is the market itself. And I would also include the price itself, because the prices are very important parts of this. Now there are various provisions which have been provided in the competition law to enforce those provisions, or to enforce the prohibitions under the competition law, because competition law is based on prohibition. Other day there was a question about the definition of the competition law. I mean, the competition law is defined in the Competition Act itself, by saying, what is prohibited and what is permissible. This is the definition, what is anti-competitive, what are the anti-competitive practices, and what are not the anti-competitive practices. So for instance, dominance is allowed, is permissible. It was not before, and now it is, especially after the 1950s, and the Supreme Court of US has allowed, and then the idea came in, I guess, 1923 in the German competition law, and the German abuse of dominance was allowed, So for all those, the mandate is to protect consumer rights, business rights and obligations, perform industry regulations, price monitoring, and prevent illegal anti-competitive behavior. For this purpose, only one, coming strictly back to your question, there has to be only one competition agency all around Pakistan, and this is one of the basic objection that has been taken by various lawyers and the entities against whom the Competition Commission has taken action, and they are in the courts. And what they are saying is, especially after the 18th Amendment, the provinces are empowered to promulgate the competition law, and the competition as a federal owned entity should not be promulgated, for each and every province and for everyone. So this is their basis. But if we read, Article 18 of the Constitution, the thing is, it becomes very clear, it says, freedom of trade, and then it is provided therein for the purpose of the freedom of trade, government can regulate, So when we say the freedom of trade, for the purpose of freedom of trade, there has to be one body which should be responsible to regulate in a way, to eliminate and curb the anti-competitive practices. Let me give you one example, for instance. Now, the markets are such that they are working, all over Pakistan. There is one product, being produced by a company. It can be sold in Sindh, and it can also be sold in Punjab and other provinces. So if we create, only one agency or one council or one kind of, different kind of authorities, in each and every places. So it would be very difficult, in one province and one court, would be saying, there is cartelization, and the other one might be saying, there is no cartelization at all. So then there will be a hue and cry, and there will be a problem, for this purpose. So what we need actually, it is provided,
Let me bring in Ms. Konain as well. Rahat Konain is here. So Qureshi
Yes.
Sahab, let me bring her in. Rahat Bibi, zara bataiye please, this issue, have we put the cart before the horse? We haven't got deregulated markets. We are still doing price controls. We are still buying wheat. The government is buying wheat. We are still regulating the sugar sector. We are still regulating the urban sector. We are regulating almost everything. Regulating means interfering in everything. The government is a heavy regulatory burden. And we've created a competition commission. And I see through most of your policy notes, you are basically giving notes that are saying the same thing. The government is regulating everything. Don't we need deregulation, or do we need a competition commission? Ji Rahat. Rahat Konain.
Kindly unmute kar le, madam.
Unmute your mic, please. एक mic का button है, उसको unmute कर ले.
One needs to clearly understand the difference between deregulation and the competition. Now, competition law has a much wider scope and ambit. Now, deregulation is कि आप regulatory framework से governmental interventions remove कर रहे हैं. That's one way of providing access to free market and promoting competition. So it's promoting competition through this tool, which is deregulation. But competition commission and competition law is just not about deregulation. It is much, much more. It is an enforcement agency. Now, as an enforcement agency, it regulates competition. Now, it may sound like, oh, it's a paradoxical thing to say you regulate competition, and on the other hand, you're talking about free markets. You ensure a level playing field for the players. It's about economic and commercial activity. Now, how do you... It's why we keep saying and emphasizing it's just not a regulatory body. It's more than that. It is not sector specific and sector blind. It has all that role to ensure providing a level. Now, Ikram Saab was just addressed. So I personally think that deregulation is and it's not sector specific. It's a much wider mandate: enforcement, advocacy, policy notes, and everything. Now, in the 4 pillars that are very, very important, how do you ensure there is a level playing field? Basically, you don't allow the cornering of markets by the players. You will not allow collusive practices. You will not allow, and rightly, I've repeatedly been using this terminology that I think a competition regulator is a referee who is enforcing the rules of the game. So there is no match fixing. It's a fair game that you have to, fair rules that you have to respect, and the undertakings have to participate in that. I would like to what Ikram was touching, and I would connect with that. We say we have got this agency. I think it is very, very important that we must understand that there have been at least, if not 2-3 phases of this agency. The initial nascent stage, which Khalid Saab started with, and we were part of the team. I was member legal then. We were also founding member. We had Mimi, we had Joseph, and we had Ghaffar Saab. So we had 4 or 5 commissioners over there, 5 commissioners. We marked the presence of the agency. And what was the biggest challenge at that time? That law was in transition. We had ordinances after ordinances, and it kept re-promulgating. It was only in 2010 when I was the chair, in fact, for 2 months, there was no law, that we, with effective lobbying, were able to have the ordinance into an act. Now, the question that Ikram was mentioning, that what is the main thrust of the argument that is pending before the courts? Why is it that there are so many courts, so many decisions pending? I think one has to understand that competition law is not unique to Pakistan, right? There are over 125 countries where you have this law as an express statute or otherwise. And everywhere it's a federal statute. There has to be some wisdom in it. Why? The basic thrust in it is that interprovincial trade and commerce, if you have to regulate that, it has to be done by the federation and not by the provinces. And the second aspect is that the reason we say we are sector blind and we're not sector specific, it is primarily you cannot regulate competition. What if entities would offer cross subsidies? There is a company which is doing business in one sector and another sector and offering cross-sectoral subsidy, you would not be able to regulate. That is why competition has to remain sector blind. So we need to have clarity. This is the major, major thrust, the federal statute or a provincial. This has been taken on against other regulatory bodies as well. Why it has taken so much time and whether it falls on Competition Commission to address it, please try to understand that from 2007 to 2010 July, it was Khalid Saab. From 2010 to 2013, it was myself. Till then, we had I had only, I have to say that at that time, we had only one DG, and that was a Gram Saab. Right now, I think we may have 8 or 9, I don't know how many, but we had very effective enforcement. We had a very good team. Nothing can be done by one individual. It was a team effort. They were bright youngsters, energetic. We were enforcing law. And that's how you see, I am a bit disappointed when I keep hearing, Competition Commission has done nothing. I feel that we form views and judgments without even, bothering and digging out what are the materials available. And it is a matter on record that when I left, I remember that we had gone to the UNCTAD peer review, which was accepted by, my request was accepted by UNCTAD, United Nations Conference on Trade and Development. And they had quoted CCP as an example of institution building. So I don't know why we keep mixing the two phases. I think, I don't want to go into why it has happened or why it has not happened, but the performance should be kept distinct. Till 2013, how the agency was viewed. And I must say there's a lot of criticism you hear when the agencies don't work. But when they work, are they ever given a pat on the back? Never. Does it ever make a basis for a parliamentary debate? Never. Does it ever come in the media? What kind of jurisprudence is being laid down? Never. So criticism apart, criticism is always appreciated, but it should be objective. So please try to appreciate that in terms of enforcement, we have done a lot. And also, last point, I just want to mention, official review is not CCP's mandate. Why the cases have not been done, if they have not been pursued post 2013, or whether they have been pursued, but it has been, this is how the litigation process is. It takes time. It is round after rounds, you have to do it. This is a separate thing to see. But this is a job that is not to be done by CCP. CCP, all it had to done and show and demonstrate whether they continued the pace of enforcement or not to provide that level playing field. And that has been missing in the last 5 years.
Achadini, I think
Dr.
please don't think that anybody is criticizing Competition Commission. That's not our job. That's not our role. We don't want to criticize anybody. We are asking very conceptual and simple questions. To my mind as an economist, it's very simple. Markets need to be deregulated. Markets need to first function. We only find anomalies like dominant player or price maintenance or price or cartels, etc., when the market is being regulated by the government. In fact, there's ample evidence to show that it's the government that creates cartels, it's the government that creates monopolies. And as we've seen recently in the antitrust cases of Microsoft and Google, etc., that antitrust law has recently changed too. Now, as I mentioned, Rahat, I was on a CUTS webinar, a global webinar recently, and I noticed there's a bunch of lawyers who are obviously putting competition laws everywhere, because there's an industry out there that seeks competition law, because lawyers are a big beneficiary of the system. Now, unfortunately, the problem is when I look at it from the side of the market participants, when I just talk to a few industrialists and people who also suffer from the Competition Commission, they are saying that, hey, we are already over-regulated. We have a huge tax compliance problem. We have a huge regulatory burden. We have a huge NEPRA burden. Now we've got another burden. So how does Pakistan industry get competitive? So we are not trying to criticize, we're just trying to understand that. But let me just go on to one thing. Let me take some questions from the floor. So Usman Kadir, will you please give us your thoughts, your questions? Usman, are you there?
Hello. Sorry about that. My question is related to the CCP and its initial formation. Basically, the CCP was formed after the 1970s Monopoly Act. There were problems in it, and then you formed the CCP to address those comments, to address those shortcomings. So I'd like to know if the CCP and its mandate address those adequately. And my second question is that the Competition Commission provides advocacy support and it's responsible for the competition culture in the country. So what's the best way to protect competition innovation in an economy like ours?
Okay. Go ahead, Ji. Kaun bolna chahega pehle?
If I can, Dr. Saab, reply to the first question. In the earlier law, the problem was that it was a toothless law. There were no substantial penalties for the violation of that law. Number one, and number two, the regulatory bodies and the governmental bodies did not come under the purview of that law as well. This is the second, and the third one is it did not allow the dominance. The monopoly or attempt to monopolize was illegal. And now this in the new law, the dominance is allowed, but prohibition is that the abuse of dominance is not allowed. So these are the bases, and I think you see, we need to understand one thing, there is no one jurisdiction where we could say, starting from US to Pakistan, and all those countries, in US, it was promulgated in 1890, the Sherman Act and then the Clayton Act and everything like that. So there is no one jurisdiction that can claim, that there are no anti-competitive practices being, carried on by the entities who are involved in economic and commercial activities. The Competition Commission has very successfully penalized the entities who were involved in the anti-competitive practices, despite of the fact, they have gone to the court, and Madam Rath will endorse, my point that we have won the cases from them in the courts, because they did not want anything to be done with them, and any order or anything to be taken against them. But then we have fought the cases before the court. It is the wrong impression, that the people have, that the Competition Commission have not done anything. It was that we were allowed to proceed against those entities for anti-competitive behavior, but we are not allowed to recover the penalties, or in some cases, to make the final orders, with respect to the passing of the orders, for the penalties. So my understanding is that the new law, which is state-of-the-art law, and it is because, I say it's state-of-the-art law because if we see the list of and the abuse of dominance or the list of the section 4, which is prohibited agreements, these are non-exhaustive lists. It is free for the competition authority to make new jurisprudence and take actions against them. I mean, for the purpose of finding a prohibited agreement, we do not have to find one agreement signed between the two parties. We can always say that they were sharing the sensitive information between themselves, and then we can culminate it towards the cartelization and all those. So I think the law has been successfully implemented and all, but there are always up and downs in the institutions. If you allow me, I want to bring up, one more very important point, because all this is related, to the performance of the competition authorities. Here in Pakistan, all those authorities, you will agree with me, Dr.
Sahab, ek baat keh do, please. This is not a competition commission trial. I submit, Competition Commission has done a great job. I'm absolutely happy with the Competition Commission has done. My problem is we don't have markets in this country. ये जवाब दें कि मार्केट्स क्यों नहीं है? अगर कॉम्पिटिशन कमीशन का इतना अच्छा काम है तो हमारी एग्रीकल्चरल मार्केट में अभी तक हुकूमत क्यों घुसी हुई है, हमारी शुगर मार्केट में हुकूमत क्यों घुसी हुई है, हमारी हर जगह तो वो मुसीबत है.
I agree with you. I agree on this point. You have given the example of deregulation commission, in Australia, but there is competition commission in Australia as well. There are markets, which are.
I've already conceded. Competition Commission has done a great job.
Let's not discuss that. Okay, let me come to your point. Your point is this agriculture is, I think, deregulated market. But what government does, which is wrong, as I can say, is that they are subsidizing, number one, and number two, they are also into fixing of the prices, and this is antithesis of the competition law.
अच्छा जी, ठीक है. राहत बीबी, आप बताइए, please. Can you tell us about this notion? Do you think we've got good markets in Pakistan?
Not have good markets and competitive markets. The whole purpose of competition and promoting competition is creating competitive markets, as Shai said.
Yeah.
Now, as we all know, there are various actors in the economic thing. जो आपकी market है ना, it's just like currency and instrument, ठीक है? And instrument does not work on its own. There are policies there, there are actors there, their conduct, their policies, all put together make a market. It's just not in isolation. Competition Commission markets create नहीं करता. उसकी working को robust बनाने के लिए, it makes sure that there are no entry barriers, that you're not competing with anyone. I think it's a very wrong test if you start with this premise कि there are not markets working, the Competition Commission ने क्या किया? I think you need to reverse the question. You need to say, has Competition Commission has it been seen to impact the markets in any way? Has it corrected the markets anyway?
We have already conceded Competition Commission has done a great job. We are worried about markets. We economists need to worry about markets.
Can I answer on the markets issue?
Rahat Bibi ki turn, please.
Okay. Oh, sorry.
Rahat Bibi.
Whether the Competition Commission has discharged its mandate adequately. That was the question. And then what is the role of advocacy? Now, responding to that question, I don't even want to list here कि हमने ये कर दिया, वो कर दिया, because everything is yet to be seen. A lot of things will come. But eventually, unless you will have a robust competition agency, foreign direct investment will not come. People will not invest if you do not have a competition authority. Number two, players, you will not have, if smaller players to join in, you will have barriers to entry, and players will be stopped from participating. How does a market become robust? मार्केट में आपने एंट्री बैरियर्स ही हटाने होते हैं ना, तो अगर आप उनकी एंट्री बैरियर्स को हटाएंगे ही नहीं, कंपटीशन अथॉरिटी जो है वो रिस्ट्रिक्टिव practices को check नहीं करेगी, तो then everybody will have their thing. So I am sorry Nadeem sir, but I think deregulation is one particular aspect which helps in promoting competition, but competition law has so many things. Enforcement is its key role. And by the way, in advocacy side, if I may add, the main mandate of this agency is enforcement, and best advocacy also remains enforcement. And in competition, in any institution, it has to establish, act independently and take decisions, bold decisions, so that markets work. How will Competition Commission help markets work? Please pick up so many decisions that we have passed. I think it would have been very helpful if we had discussed the LDI operators case in telecom, if we had discussed the urea pricing where 86% price hike had taken place, and we did what we could have done, and then how it impacted whether prices down after that or not, whether all will be actually a lot more dependent upon the judicial review, which is still pending. So I'm sorry, I don't want to
No problem,
time on
no
this,
problem.
but I think we must distinguish between.
No, we will. Let me bring in Senator Musaddiq Malik. Senator Saab.
जी थैंक यू मेरा ख्याल था कि हमारी डिस्कशन थोड़ी सी कंसेप्चुअल होगी बट इट्स अ लिटिल बिट मोर अबाउट एज यू सेड putting the commission on trial which is not why I joined. I thought we'd talk a little bit more about
Neither do I. We don't want that either.
Right, but apparently that's basically what's happening over and over again. But while we're at it, if we're going to talk about it, I think it would be important to take a view on the outcomes, and no one is interested in a particular case or a specific case. But in terms of the market impact, for example, you gave the US, you made a rolling mention of the US, and billions of dollars have been appropriated to Microsoft for anti-competition practices through the courts, etc. And there's a very clear anti-competition law. So one, if this is about the competition law and the commission, then what has been the outcome? And I'm not interested in the listing of cases. I would like to understand what kind of penalties have been or economic damages have been appropriated to companies over the past, since 2013, because you're saying after 2013 it was a different era. So one would like to have a view in terms of the investments that we are making in the commission versus the benefits that people are getting. And the second and more important thing is I'll give a little bit of a layperson's view on what Dr. Nadeemul Haq was saying. I'm just coming from the finance bill meeting, finance committee of the Senate meeting. And there were people joking about it. I mean, they tell you stories in terms of gatta banane mein kab humne ek meeting ki aur uske baad to humne price fix kar di aur wo chalta raha. I can personally tell you I was chairman of LESCO, and you can pick up any LESCO procurement contract and you will find that if basically 750 meters were required, 3 companies would bid, and they would bid 250,000 meters each, and their price would be within 1 rupee of each other, and all 3 of them would end up getting the 3 contracts. They would match the lowest price. The lowest price would be a rupee less than the highest price. And I then also, when I was SAPM, I did the analysis on the utility stores, and we found exactly the same. We saw very clear, a glaring case of people doing price fixing. We looked at the concentration in terms of how many vendors have been, and you find such enormous concentration in terms of 3 people supplying the sugar and wheat and number of things for the entire utility corporation. So what I would like to see is that, and at that point in time when I was chairman, LESCO, I actually said, let's go to the competition people. And I think we spoke with someone as well. I don't completely recall. I can go back and look at the notes. And apparently the commission was paralyzed. We went everywhere, and there's not jack we could do. And the only thing that ended up happening was that the entire board was dissolved. And those people who were involved in anti-competition practices, they prevailed, and they probably continue to do the same kind of bidding with 3 vendors bidding for 1 million pieces each when the bid was for 3 million and the price differential of 1 rupee. There's glaring cases and nothing. So
Nadeem, would you like to comment on that?
Yes, I would like to comment on that, and I would particularly like to comment on the particular case that Senator Saab has mentioned. And I think he missed the press briefing that we issued 2 weeks ago, where we have caught a cartel. We have issued show cause notices to 47 suppliers of the discos. They were supplying miscellaneous items, and they were blatantly involved in cartelization as per the inquiry report. They had made a cartel in terms of the inquiry report. Since it's still at the inquiry stage and we have issued a show cause notice, we have not made the final determination. We will make it after hearing out the parties. But apparently, from the contents of the inquiry report, they were involved in bid rigging. They were colluding, and they were fixing the prices, fixing the quantities, and they were supplying different items to all the discos. And this case was initiated in 2016, and we conducted an inspection of the premises. Our inquiry teams conducted an inspection of the premises of these companies. A similar case was we had and conducted an inquiry in Ma'am Rahat's era, and she could remember it very well that the transformer suppliers were also caught by CCP in a cartel case, and we also got a leniency application and leniency order in that case as well. So we are looking procurement as our priority area because it is a significant part of our GDP. The procurements count a significant part of our GDP. And we also, in collaboration with the different developed competition agencies like the UK and the Korean agency, we have developed an in-house system that is called bid rigging analysis and detection system. And we have signed an MOU with PEPRA as well. And through this system, we would be able to monitor all the procurements above a significant value. Then we will make the entries into the system, and the system will generate red flags in case there is some abnormality in the procurement process. There are similar bids, or there are indications of cartelization. So that system would be the trial is over, and the system is in place at CCP. And we hope that we would be able to effectively enforce our law through that system, particularly in the procurement cases. Secondly, our law, our definition of undertaking in the law is very clear. It includes the government undertakings as well. And we have proceeded against the government entities in various cases. Like one of our first cases was against PIA, where we imposed a penalty on PIA for unreasonably high prices to the in the Hajj fairs case. Then we have proceeded against utility stores. We have proceeded against engineering council. So our law applies to the regulated sectors and to the government entities as well. So I think the visibility of the commission will improve with the passage of time once our cases are decided in the courts. And I'm very happy to share that the Attorney General is himself going to argue our case tomorrow in Lahore High Court. And we are hopeful that we will get a decision in that case soon.
Great. Let me bring in Uzma Zia. Uzma, do you have a question? Quickly.
Yes. My first question is with Madam Shaista. As you have just discussed the case, I have come to know that CCP has a carrot and stick approach, what they use. So up to what extent do you provide the leniency? Just suppose that if the firm is found guilty, then they must be punished also. So up to what extent you can provide that support? Then I have another question, and that question is from Mr. Qureshi. As we have seen that in case of Careem and Uber merger, we have seen that after the merger, their combined share in the market has increased. It has become doubled. And the commission allowed them to use the surge price cap as 2.5 times up. So in this case, they can charge more. And previously you said that consumers' right should be protected. In this case, I think consumers' right is not protected. So can you speak on it?
Go ahead.
Yes, we have a leniency program in Competition Commission. And under that leniency program, we can provide up to 100% of immunity, but there are certain conditions to that, attached to that 100% waiver. And these include the cooperation, the amount of additional evidence that the entity provide against the other cartel participants. We also have another program that is a whistleblower program, where we, if there is an informant, because leniency comes from the cartel participant, the leniency applicant has to be part of the cartel. But the informant program can be availed by anyone who has a concrete information about the existence of a cartel, and we can, we have an incentive up to 1.5 billion rupees to the informant. So that is divided into different stages, and we have that in place since 2013, 2012, 13, I guess. So, and there are a number of applications that have, the leniency application has been availed so far once, but the informant scheme has been availed twice or thrice in the commission. So we do have a carrot and stick approach, and if there is some concrete information, then we do act upon that.
Good. Now I'll be in the informant business very soon. क्यों जी कुरैशी साहब बताइए?
Sir, मैं इसमें ये गुजारिश करूँगा कि if the competition authority, if they find evidence that after consummation of the merger, there are anti-competitive practices, because of the merger, within 1 year of the consummation and approval of the merger, the competition authority can open up this case and can disapprove the merger, or they can place in more conditions, in order to avoid, this kind of price increase as has been told by the speaker, just now. So the merger, can be opened up, within 1 year if the 1 year has not been passed.
Can I just add?
Rahat Bibi ji.
When Shaista has just mentioned about the leniency decision, which was termed as regulatory breakthrough, you'd be surprised to know that Siemens came forward with 233 documents, right? And placed all those documents and everything before the court. And yet, with the admission of guilt, the stay was not vacated. So try to understand the challenges that CCP is also facing. And coming back to Musaddiq Saab's comment as to you want to see the deliverables, please also try to understand what are the challenges of competition agency. Ishrat Saab's report on CCP, it points out very succinctly that 358 million and was what was the budget that was given to CCP, and 1.5 billion that of SECP. And then SECP is sector specific and CCP is entire economy and sector blind. Is this a budget to match and empower an agency who has to discharge such a big function? I mean, what are our, I don't know, when I left, I think hardly 46. Now you may have 75 officers or something. Shaista, please correct me if I'm wrong. With this team, how many economists, how many lawyers, what is the quality and level of research that we are targeting? And despite all odds, I mean, I'm not saying please कि आप किसी judgment पे जाएं. Deliverables are also linked with the challenges an agency faces. How you are empowering them, how you are giving them that which you expect. So इसको एक holistic approach के साथ देखना चाहिए. I think there are a lot of challenges for this agency. And if there is a political will, if there is support, then the deliverables would be different. I think that's the main thing.
Mera jo problem hai na, and I go back to Musaddiq's point. Dekhiye ji, if Musaddiq Saab, if the Competition Commission is necessary to fix government procurement, I'm sorry, we don't need that. We already got PEPRA, right? I want to see working markets in this country. As an economist, when you ask me to make a plan for this country, a growth plan, I can't make a growth plan because there are no markets. When we talk to our investors, we talk to a lot of investors. They say that there are no markets in this country. Why do you want me to invest? Where do you want me to invest? So I really want to know, I'm not talking about Competition Commission. Competition Commission, mashallah, has done an excellent job. I've got no problem with it. I've got problems with the fact that we have no markets in this country. From construction all the way up to agriculture, to industry, to whatever, we have no markets. When you say entry barriers, the entry barriers are set up by the government. The market doesn't have entry barriers. It's the government that has entry barriers. So I come back to my original issue that we need deregulation and not competition. That's the problem. But in any case, let me go to Samir Ahmed. Samir, will you ask a question, please?
Sure, thank you. I'd just like to build on this point, the deregulation versus competition kind of thing. Ikram Saab had said earlier that, Competition Commission operates within its own guidelines and policies and so forth. Rahat made the point that competition remit is much wider than just the deregulation side of it. I was wondering if there is anything that the Competition Commission under the Competition Act can do in terms of facilitating or, enabling more deregulation, whether in the name of efficient markets or consumer welfare? What is it, if anything, that the Competition Commission can do? That's one thing. The other thing was, regarding the performance and so forth. Two things have come up. Ek to ye hai ke a lot of cases stuck up. So, and looking from the outside, I could be wrong. I have not seen the Competition Commission, or at least that's not the general impression, that it's a very vibrant, alive body. I mean, if there are cases stuck, yes, you can partially blame it on the court system that we have. But how much work or how proactively has the Competition Commission been working on these cases? And the other point which Rahat made in terms of funding, again, as I understand it, the law, the rules say that XYZ has to pay X amount of fees, and the fees are not being paid. So can these things be enforced? I mean, how can we make it a more, a more vibrant, a more effective institution?
Ji, Madam Shasta. Shasta Bibi.
मेरे ख्याल से ये मेरे से क्वेश्चन तो मेरे कमेंट से रिलेटेड if you please allow me to answer sir on this. जी सर, मैं ये बात दोबारा से क्लियर करता हूँ. Deregulation is very important, but the competition authority is not mandated to deregulate any market or any sector whatsoever. There is no provision under the law. This is one thing is clear. There is only one section, which is section 29. And under that section, we can issue the policy note to the government of Pakistan or to other provincial governments saying, this is the market, this is what is happening. Please open it up like this. Do not do this. These are the prohibition and all that kind of stuff. But otherwise, there are two types of provisions, in the law. One is ex ante and one are the ex post facto provisions. The ex ante provisions are to be provided by the sector regulators. And they include, the economic structures of the market or the sectors, That is the job of the government and the sector regulators, precisely, And then it comes the role of the competition authority, and that is, ex post facto. What I'm saying is that if you violate the competition law, then there are prohibitions, For the purpose of those prohibitions, it is the job of the competition authority to ensure, to eliminate or those, prohibitions if they find anything and pass the order, But now, by coming the second, on the cases and the recovery of the fines, you see, this is what it has been provided, under the law. There is a fundamental, problem in the law, to my understanding, that I have seen now, and that is, the high courts, the Supreme Court, and then the Competition Appellate Tribunal. Competition Appellate Tribunal has not been, functional for such a long time, probably it is not functional even right now, I could say. And because of that, even if it is functional, the private parties or the entities against whom the competition authorities issues the show cause notices or even letters, asking for the information, what they do is that they get into, forum shopping. Some people go to the high courts, some people go to the competition authority, and then there is no competition appellate tribunal. Then the thing that's stuck there, and then the high courts and the Supreme Court, later on. So it is my considered view now that maybe it is a good time, to think over this strategy, or the procedure, and maybe we may eliminate the competition appellate tribunal and give this power, to the high courts, with a competition tribunal there or competition, benches there, and let, the appeals to be filed, before the high courts, and then the high courts will be allowed, to pass the orders, and the orders will be filing, the appeals will be filing before the Supreme Court. And coming back to the markets, there are so many markets, which are very vibrant, and they are very, competitive between each other. Number one is telecom market, which is kind of, I would say, except, 2-3 problems that we have found out, it is hyper competitive, and the banking and IT market, and then, also the home appliances, the markets are always there. The sectors are always there. Probably more has to be done by the government, and maybe more has to be done, by the competition authority also, in this regard.
Ji,
I would like.
May I make a couple of comments after Ms. Shaista? Ms. Shaista, please carry on, because it would address a couple of questions also. Thank you.
I just wanted to make a point that we are again talking about the deregulation and its impact on development of markets. But we see that we can observe that regulatory barriers are one of the entry barriers for development of markets, but there are other barriers as well that only the Competition Commission or the existence of an effective competition authority can address. There are structural barriers in the market as well that are not connected with the regulation. For example, if there is a cartel existing in the market, they do not let a new entrant enter in the market through different means like predatory pricing or any other hindrances that they can create through cartelization, or sometimes there is a dominant player in the market who does not let any other player enter the market. For example, you can say the auto sector is a deregulated sector, but still there has been a very less new investment and new entry in that market, and that market has not been able to develop. Was it due to regulation? Can we completely blame the regulation for can we make it the only responsible factor for our failure in developing truly competitive markets? So that is my one point. And the other point is that regarding the financial independence of the Commission. So recently there has been some development in the recovery of the 3% fee that was from the regulatory bodies that the government has now through the Public Accounts Committee. They have issued a specific direction to the government to ensure that this 3% fee is made available to the Commission for its independent functioning.
Okay, great. Senator Saab, let me tell you, this country is highly over-lawyered. Can you please pass laws in the Senate to simplify our laws? I can't work my way through the Competition Commission law, through the price committee law, for this law, that there's tons of laws. Kya keh rahi hain, Malia?
First of all, I think I have to congratulate Ms. Shaista, because 2 or 3 very good news she's shared with us, and progress is being made. So I think that's really heartening to know, because we set up this this commission with a lot of heart and with a lot of conviction and sincerity of purpose. I think a couple of things I want to touch upon. One of the things that I think time and again, Dr. Saab, you're talking about is deregulation, and Samir also asked that what is the role that perhaps Competition Commission can play? And to my mind, I think it's the advocacy role, the advocacy policy notes. I think what you had touched upon is many of the markets we observed were actually being warped in terms of competition, and actually dominance was being created because there were players who were government or semi-government players within those markets. So when the government intervenes through over-regulation or trying to even monitor prices or fix prices, which was touched upon, becomes a player in that market and becomes part of a collusive group or part of a cartel. And I'm not going to name names, but it was so we observed in 2-3 different industries, and Shaista smiling because she remembers. It really warps the dynamics of the market, and also there tends to be regulatory capture. And I forgive me for saying that, but there is sometimes regulation created to favor the strong lobbies, and so so that is there, and that again warps competition. So the challenge is very tough, but I think advocacy has a fantastic role, which has been demonstrated in jurisdictions like Singapore. Now, let me just, because I've lived in Singapore, I've worked there, let me just highlight that there's an index, the Global Competitiveness Index, which is the World Economic Forum's index. And then there's another one called the Institute of Management Development Index, which is again a world competitiveness index. And on both of these indices, that's Switzerland based as well, and it has some 63 countries in it. Both of these indices have Singapore coming on the #1 slot. And since I've worked in that market, in the financial markets there, I've observed one thing, and I think that that's very important, is the importance of advocacy and engagement with the private and the public sector. Because the public sector is also, even the regulators, and in our time, were being sent advocacy notes. There is a lot that you also have to encourage within the regulators. And so I really believe that, yes, the short answer to Sameer's question is yes, Competition Commission does have a role, and we ourselves as the Commission have to recognize that role, and within the ambit of the law, take it further. Thank
Rahat
you.
Bibi, can I ask you a very simple question? Advocacy ki baat kar rahi hai, and absolutely, I think, do you think there should be a market in advocacy too, or should you have the monopoly on advocacy? Because now the advocacy is done by agencies of the government as well as donors. Now, where is civil society? Can't they do advocacy? Now, second question, Rahat Bibi, I also want from you is very simple. You also have exemptions on your website. There are more exemptions than policy note. What are you giving exemptions for? I couldn't figure that out from your law, or otherwise, as I said, you're over-lawyered. So I have no idea on how to read this stuff. I need to hire a lawyer to read this. The third question that I have is very important also. One of your policy notes on commodity pricing actually says that you should have more price fixing, and the DCs should do price fixing. And there's a whole paraphernalia that you got on how the bureaucracy should be fixing prices. Is that competition? Is that what the Competition Commission is for? Ye Rahat Bibi. I can't hear you, Rahat. I think you have to unmute your mic. Unmute your mic.
Okay. Can you hear me?
Now we can hear you. Go ahead.
First question is related to what Maliha said, and because I'm a great believer in enforcement, for Competition Commission, the wisdom and the gurus have always stated that enforcement is the best advocacy. What do you advocate when you have not done enforcement? Now, what is enforcement is the 4 pillars that you have to enforce to create a level playing field. So actions speak louder than word. You have to discharge your mandate, do the enforcement, that will do the advocacy. And whatever sector, whether the government, एक चीज में बहुत clearly इसमें I think one needs to point out, you are an arm of the government. If you are an institution, you are an arm of the government. Now, as an arm of the government, that does not mean you compromise your independence by agreeing with the all tweaked and distorted policies. You are there to advise. There comes your policy role. There comes the public hearing. There comes Section 29, where you can advise the government is doing wrong in this case, just as we did it in the LDI case. Just as we have done it in so many, there are, I think, over 30 policy notes issued to the government, various departments. Second, exemptions. It's a pretty simple. I must say that Competition Act is one of my favorites. This is the thing which I carry in my purse, and it's like very precise, very simple to understand. Exemptions you grant under law, where let's say you have a distribution agreement. Now you give exclusivity of distribution. Now in business practice, exclusivity is something that works out in enhancing the efficiency in a particular territory. So you will exempt, while exclusivity otherwise is something which will restrict competition. Competition is allowing you in a template exemption to all such distributors that you can do it in a particular territory because it's in public interest, because it is enhancing economic efficiency. Eventually it's contributing. So exemption has 3-4 criteria of the Section 4 and 5. If you meet that, you will be given. So it's about block exemption and individual exemptions, and to facilitate in our time, we were even similar agreements of which were alike, hundreds of them were just charged 1 fee for ease of doing business. So it was not meant to have rent-seeking objective. The third part was controlling and fixing prices. Now, the commodities, the essential commodities, we talk about, it's about controlling prices. It's never about fixing prices. Please read the law. It never says you fix the price. Whether it's the Supreme Court or whether it's the government agencies. If we do fixing of the prices, we may be doing antithesis of competition, right? Why do you control prices? It's just like you give subsidies. It's just like you have this in wheat and anything, minimum prices fixed. This even happens in the most advanced economies. It's not something that you need to worry. It's just to ensure that people don't abuse that and that essential commodity finds its way to the common man. Controlling prices is not same as fixing prices. I'm again saying Competition Commission has no role in fixing prices. If it does that,
it's okay to control prices through DCs.
Yes, through DCs.
Through DCs. That's the Competition Commission's finding.
Provincial governments are there to see and oversee. वो जो मंडी का आपका पूरा सिस्टम है कि prices बहुत ज़्यादा हाइक पे ना चली जाए, होर्डिंग ना हो जाए, और बहुत ज़्यादा अक्सर लोग ये कहते हैं कि जी होर्डिंग हो गई है, आपने कुछ किया नहीं. अब होर्डिंग में और कार्टलाइजेशन में थोड़ा सा फर्क है. अगर मैं अपना any economic producer, if he is having his produce, he can hold it back and sell it if he wants. But when we collectively do that, which was a case in the sugar case, I remember in 2009, this was pointed out in one of the inquiries, and even not in 2010, we had to go up to the Supreme Court to enforce that, where Pakistan Sugar Mills Association had actually found in anti-competitive practices in setting that price. So I think all things have to be understood in a plain and simple language, that we are not for fixing prices. We are not for anything which is anti-competitive.
But you're for controlling prices. That's good. That's good. You're for controlling prices.
We are not sorry, Dr. Saab, can I just a short comment? For controlling of any prices or fixing of any prices. Competition Commission never supports any fixation of the prices. Rather, Competition Commission looks the high or increase of the prices, and that is, under the framework of the competition. This is number one. And another comment I want to make it about the registered associations, which is provided under the Competition Act. In various, European countries and USA, there are very strong consumer protection associations are there, and they are the one who are helping the competition authorities by bringing, various cases and various issues in front of them, and then the competition authorities are taking action. Here in Pakistan, only the Competition Commission of Pakistan is involved in the advocacy, which is a good thing, but it is rather, not working as it should have been working.
Okay. Thank you. Senator Saab wants to come back in. Senator Saab, please. The lawmakers should take more attention, pay more attention to the fact that this legal morass is being created. We citizens are, dying under this morass. Help us think it through. Bataiye.
Thank you very much. I would take the lead from the word advocacy, which I kind of sparsely understand. But what I'd like to do is I'd like to make myself available. So I'd like to make myself available to the Commission, and I'd also like to make myself available to fight, to lobby for deregulation of the markets. I don't think any bureaucrat in the world can tell us what the price of anything is going to be. Why do you have markets if you need bureaucrats? And if you have bureaucrats, why do you need the other way around? I mean, you want a DC to establish what a price should be. And then you need basically the DC and the police to enforce the price in a particular district. Why don't you pack the markets and send them home? And why don't you have a bureaucrat everywhere establishing, running factories and delivering goods and establishing what the price is going to be? Why have a demand and supply function? Why basically ease the barriers to entry, which I think should be the first thing. What I would have liked to hear from the Competition Commission is that we lowered these barriers, and therefore the supply side was enhanced with an economic impact of 3 trillion rupees in 1 year. That's what I would have liked to hear. That people, I would have liked to see something for the sugar market where only 8 companies or 18 companies are allowed to manufacture sugar. Why not 18,000 companies, and let the most efficient ones survive and the rest go to hell? I mean, if I open up a school today, would you subsidize me? Would you tell me that no one else can open up a school here in southern Punjab? Let the best school prevail and let people take business risks. So I would have liked to see from the Competition Commission the measures that they've introduced to lower the entry barriers. The measures where basically the price fixing goes away because neither the bureaucrat nor two factories are fixing the prices. So I hear like these people who hoard or people who do collusion, and I'm absolutely against it. But what I don't hear is basically let's work on this, removing the barriers and let the markets take care and decrease the burden on the ultimate consumer. So if you guys are interested in that direction, if you are interested in bureaucrats, that by God, I'm going to oppose it in the Senate every step of the way. But if you are basically interested in increasing the market competition, and having measures in place and laws in place that ensure that there is no hoarding, that there is no price fixing, that 5 big players, because there are only 5 because the entry barriers are very high, they sit together and decide what the price is going to be, then I am completely in support. And today I'd like to use this forum to make myself and many of my colleagues available. I'd like to lobby for you and not just have discussions, but turn them into laws, because we don't have any staffers. We cannot write those policies and laws that we need to take to the floor. So if you're willing to help us write those, because in Pakistan there's no such infrastructure, and you are the think tank and the commission is an agency. You have the agency. So I'm available, and a number of my friends are available, and we would take these bills.
Take you up on that, Senator. Very good offer. We'll take you up on that.
I agree with Senator Saab, but there is only one point is, in different markets, they have their own dynamics, there. By saying, that sugar mills could be in thousands and stuff, that might not be possible because of the pricing structure and everything, this is how, it takes for setting up a market, but it is important that we should have optimum number of markets, like for example, in telecom, there usually in the world, there are 4 or 5 of the telecom operators, they are working. But, there are other virtual operators, they are also working, but the major operators are 4 or 5 numbers of them. So I agree with them, but in this sugar case, we have issued a policy note to the government of Punjab. Madam Rath will remember that. And we have asked them, to eliminate the entry barriers and let other people having more, sugar mills in the province.
I'm sorry, I'm cutting. I know, Nadeem, would you allow me? What I don't understand is how is a bureaucrat rather than the market better situated to decide and understand how many players are good enough? I mean, there must be some measure that the market doesn't understand, and someone with a master's degree, one person sitting in a cubicle can decide. And then not only decide, but enforce. I mean, I don't completely understand. And I remember the days when there was only one telecom company in the United States, and it was broken. It was broken to create companies.
Yes, in 6 parts.
Hear me out. And I have just come out of the finance, reviewing the finance bill line by line, and I can tell you where the elite capture is in every line. I mean, this should be 2% and this should be 7%, and you can discuss till the cows come home. And the basic thing is that every line is there for a certain kind of elite capture using the exact same kind of bureaucratic logic. यहाँ पे हमने इसको बचाना है और यहाँ पे हमने इसको मारना है और यहाँ पे हमारी, I mean, why? I mean, why don't you just lower the entry barriers and people come in and compete, and the competition would bring the prices down, and it would make the burden, the economic burden on the end consumer lower, and that's the only intent we have. So my view is, and there are exceptions, and really I don't want to discuss cases here, but I am saying I'm making myself available. I'd lobby for you if it's against colluding and you can show me, I'd lobby. If it's against price fixing and you can show me, I would lobby. And if it is about deregulation, which includes enhances the supply side, lowers the entry barriers, I'd lobby. If it is anything that is bureaucratic, by God, I'd oppose.
Good point. Shahnaz, क्या कह रही हैं आप? Shahnaz Wazir Ali? Shahnaz, you need to unmute your mic. Unmute your mic, Shahnaz. Shahnaz, unmute your mic. यहाँ से इनका माइक अनम्यूट हो सकता है? नहीं शना,
Now?
हाँ, बोलिए बोलिए,
Okay.
अब बोलिए.
Okay.
हाँ जी,
All right. I think you were controlling it from your side. I've been listening very carefully, and some of my colleagues who are in this program, Rahat and Musaddiq, and yourself. I'm not a market-based person. I don't have technical expertise. I'm just talking from a slightly different context. You know, obviously there's an evolution here. For years and for decades in Pakistan, there was a system of plots and permits and licenses, as we all know. This patronage system, which obviously is an elite capture system we have lived with for a long, long time. It's changed its contours into a very sophisticated game of political lobbying, which allows a certain group of people or a certain category of people to have access. And they have created large monopolies. The Competition Commission came along, but was fortunately at some point in time, the government of Pakistan and the parliament realized that, you know, this cartelization, collusion, and elite capture needed an institutional framework of the Competition Commission. And I think the Competition Commission has actually worked in very, very difficult circumstances. And even today, when the writing is pretty clear on the wall, that there is a lot of monopoly. Sugar is clearly one instance, several others, cement is there too. My question really is that clearly we are, I think most of us seem to be in agreement that we want to move towards a leveling of the playing field so that open, competitive market forces can apply. And then through the creation of market forces, supply and demand actually fixes the price and the consumer gets that advantage. But this sort of a system, this, perfect solution is obviously not going to happen immediately. And there's no utopia anywhere. Even in the United States, there's not perfect competition. So for Pakistan, developing country right now in a nosedive as far as the economy is concerned, probably going into a minus GDP growth rate, what would be the steps that would be necessary now at this stage of development and evolution that experts and the Competition Commission is proposing? So far, there has maybe some progress has been made, but we know that there is still elite capture. We know that the entry barriers are high. We know what sort of entry barriers are created. One, through budget lines also, like Musaddiq has just said, but there are multiple entry barriers. So for me, I would like to look at what is the Competition Commission doing, which in the next 2 or 3 years will demonstrably show us that we have moved towards a market-based, supply-demand driven arrangement. So far, it doesn't seem to happen. If you look at, I'll just give you one example, the pharmaceutical sector. There's a drug control authority. Now, the drug control authority is actually supposed to vouch for the chemical and the medical standards that a particular drug is supposed to comply with. But the drug control authority does more price fixing than it does quality control. And the Drug Control Authority's legislation allows it to do a lot of fixing of prices. So you have this system continuously of pharmaceutical companies who organize themselves into the Pharma Bureau lobby, which goes and lobbies, and we know what all happens with those lobbies, and a lot of patronage is extended. And the company that has the heaviest clout manages to get away with the highest prices fixed for its drugs. So, there are, on the one hand, there's the Competition Commission. On the other hand, we are doing things which clearly regulate the market in such a way and fix prices. I think go for quality arrangements on the drug regulation. That's what it's really supposed to be about. Okay. Is your chemical formula right? Are your production procedures right? Is ISO 9000 certification being applied, et cetera, rather than fixing of prices? So I wanted Competition Commission particularly to address for me this whole question of control on drug prices, because I deal a lot with the health sector, and with the crisis right now, which we are all consumed with, we are seeing a lot of very, 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 very distressing situations occurring in the pharmacy.
What would you say to that?
The point is well noted, and it is a very pertinent point that there has been issues in the pharma sector, and lastly we tried to look into it, and we conducted an investigation, particularly of the Pharma Bureau, with respect to any possible violation of the Section 4 of the Competition Act that primarily deals with cartelization. And the order came out, and it appeared that the prima facie case was not substantiated, and they were cleared in that case. But the takeaway from the case is very quickly pointed out by Ma'am Shenaz that there has been active lobbying by the pharma companies to get the price increase that they desired. There are few categories of the product that are life-saving drugs, and there are normal drugs, there are patented drugs, they have patent protection as well, and there is a lot of R&D involved in developing a new pharmaceutical product, and there are a lot of patent rights and IP rights attached to it that are also protected by the IP laws. So there are issues in the pharma sector, and we are also planning to conduct a competition assessment study of this sector that will look exactly into the areas of where the competition can be improved in this sector. So as regarding your question regarding what is our future planning to improve our effectiveness as an institution is there are a number of plans that are obviously tied with certain things, the outcome of court cases is number one. Then our appointment of members is still pending. Currently, we are only 2 members, and our constitutional quorum is not complete. So in certain areas, if we see some irregularity, we cannot initiate cases into those areas because of the non-existence of the quorum right now. Then our competition appellate tribunal is still not functional. All the 3 members have retired, and they have not been reappointed as yet. So there is another impediment. Plus at the structure level, we are considering some changes as well to look into the areas which were not previously pursued very effectively. And one of them is collaboration with regulatory bodies and with the government in policy making. We are trying to increase our role in the government policy making. For example, we recently issued a policy note where we have asked SCCP to reintroduce the cost audit, because we want to have an independent source of information available to the policymakers for an effective and informed policy making. So we are also pursuing that policy note with SCCP, and other Ministry of Industries have endorsed our policy note. Ministry of Finance is also backing us on it, because it is a very important area, because once we don't have any independent source of information, then our reliance on the association increases, and their role in the policy making is unduly emphasized. So these are the areas we are trying to internally restructure us. As I told you that we have introduced a bid rigging analysis and detection system. We have also introduced an online merger application form to facilitate the applicants who want to apply for a merger case. We are also, in the near future, we will also make the exemption application online as well. So we are moving toward more introducing IT-based solutions. We are also into online hearings as well. All our hearings are being conducted online without any, due to this COVID-19 situation. The physical presence is not necessary, and it is also making us more accessible for the public, because sometimes if the applicant or the respondent is in other city and he or she cannot travel, the provision of this online hearing is not only saving the cost, but it is also making us more accessible. So these are the few steps that we are taking. Hopefully, we will be able to achieve some positive results.
I think कुछ लोग हाथ खड़ा कर रहे हैं. Let me quickly take
one short answer to the question.
Quickly, ये question दे लो, then we'll come.
Okay, well, very quickly. There are two things which have been done. Number one is one is for the Senator Sahib, and that is who can file the complaint with the Competition Commission. It is the undertaking, and undertaking is defined under the law, and that is not an ordinary person. That is a person who is involved in manufacturing or producing or providing the services. They are the people who can only file the complaints and raise their concern, no one else. This is number one. This has to be get away with. Anyone should come and file the complaint, number one. And number two, and more important, is that there is a provision which is preparing studies for the purpose of the Competition Commission and taking the suo motu actions, which is also provided under section 37. It is very important that research studies and all these sectors have to be done by very good researchers and all those people who are experts in those sectors, and because of these studies, they will find out what are the anti-competitive problems and where the Competition Commission should take action. Otherwise, it would be very difficult for the Competition Commission to take, all those action. Obviously, they are doing their best, but still, there are problems. Thank you, sir.
Let me take these three questions together so that you can answer them together. ठीक है जी? बड़ी देर से बेचारों ने हाथ खड़ा किया. Sarah Niz.
Assalamu alaikum, sir. My name is Sarah Nizamani, and I'm a research scholar from Applied Economics Research Center. Sir, since the CCP panel is talking about overlooking the markets and reporting to the government, I would like to ask, how do they take these decisions? I think all the people in this, all the economists in this session will agree that there is no such thing as the cost of producing a given product or service. Henry Ford proved long ago that the cost of producing an automobile was very different when you produce 100 cars a year and when you produced 1,000 cars. Similarly, if we take an example of cost of production of electricity, we can see that it can vary enormously depending on when and where it is generated. When you wake up in the middle of the night and turn on a light, that electricity costs practically nothing compared to supply because of the excess capacity. But at the same time, if you turn on an air conditioner on a hot summer afternoon when millions of other peoples and homes are using it, it's completely different. It has also been estimated that the cost of supplying the electricity required to run a dishwasher at the time of peak electricity can be 100 times higher than the cost of running the same dishwasher at the time of the low demand for electricity. So my question is that how is the regulatory commission to set the rates of to be charged consumers of electricity, given that the cost of generating electricity or any other product that can vary so widely and unpredictably? And if I'm going to get an answer of the average cost, but average costs are irrelevant when it comes to cost of generation of such products. So my question is, how do you decide?
Very good question, Sarah. Very good question. Keep it up. जी, अवैस हसन शेख साहब, आप बोलिए.
This is Dr. Wes Sheikh. I have I'm currently teaching in Karachi in a private sector university. I have a PhD in IP and competition law. Actually, I have a very broad question, and from the very beginning, I've been listening to Dr. Nadeem Saab's assertion, if you allow me to say, and I would like to kind of categorize that assertion into an issue of competition policy more than an issue of competition law. Because the moment you start looking at competition law, you necessarily look at the CCP or the competition authority. The moment you go back, step back and talk about competition policy, you're talking about each and every player, or not only player, each and every influencer, including the government. So my question is general, but it is to Nadeem Saab. Wouldn't you actually, or shouldn't you actually kind of put your question from a perspective of the competition policy, which is impacted by obviously a country like Pakistan have an acute developmental focus. And and I do agree with you that when you say there are some interventions which are, even from a development economic perspective, are not the best. I do agree with that. And yeah, so actually I had two questions that I've now put them together. So that's my question to the economists here.
Okay. Fair enough. Fair enough. Ji, last question, Taimur Bhatt sir.
Assalamu alaikum. My name is Samur Bhatt. I am from student in PIDE and I'm from Temple TS. I have a question from the panel is that we have been concerned about the cartelization or monopolies or, in sugar industry or in pharma industry. But what about the cartelization in the automobile industry as well? For example, in Pakistan specifically, if you want to purchase a car that is low on budget, then you can move to Suzuki. A car which is higher in price, more in luxury, you can move to Toyota. Or in the mid-range, we have Toyota and Honda. Why is that so? Why isn't there competition or pure competition in the market, especially in the automobile sector? Thank you.
Question. जी, panel अब बताइए जी, राहत कोनैन बीबी आप शुरू करिए. Rahat Bibi, are you there? चलिए
Or I
जी.
can start with the question. I can start with the answer.
शाइस्ता बानो बीबी, आप शुरू कर लें.
जी, I start with the automobile sector. And the question was that why there is lack of choices and lack of the competition. We conducted a public hearing in the auto sector 2 years ago, and we had all players and all stakeholders. And we issued a public opinion. Different suggestions were made. And it is true that there has been sort of a monopoly in this sector in different categories of cars, and we have at various occasions we have looked into it, and there were some conditions in the provisional booking order, especially in the Indus Motor Company, and we made those conditions. We made them to change those conditions in the favor of consumer. But I think the main issue in the auto sector is that the size of the market and the type of investment that is required in this in this sector, because the market size is not enough. There have been studies, a lot of studies that showed that the precision parts are not being still manufactured in Pakistan. That's why the cost has not come down. They still have to be imported, and they are impacted by the dollar price. As the price increases, the dollar price increase. But after the auto policy in 2015 and during the last year, new players have entered the market, and we can hope that these players will sustain and the choices for the consumer will increase. As long as the question regarding the cost of production and things like that is concerned, since we very categorically said that the Commission has no role in price fixing or price control. So we do look into the prices and the cost structures when we investigate abuse of dominance cases, usually. When there are allegations of an unreasonable price increase, and these are the most difficult cases to establish, because we have to corroborate it, the prices with the gross profits and the prices of the parallel products, and we have to establish it with the angle of an abuse of dominant position by a dominant player. So if the unreasonable prices are coming from a dominant player, and they are also making huge profits, the profit margins are also unreasonable, then we can, to some extent, in some cases, we have established that the price increase was unreasonable, but still we cannot say that what is the reasonable price. So there is always a dilemma in such cases. The cost structure are relevant to the Commission only to that extent.
Sir, after Madam Rahat, I would also like to make a couple of comments, but Madam Rahat is there, so she can give the answer.
Have you unmuted your mic? Rahat?
hear me?
We can hear you. Please, ji boliye.
On the auto sector thing, I think
Zara uncha boliye. I don't think we can hear you very well. Zara uncha boliye.
on the
Or
auto
get
sector,
nearer the mic if possible.
I believe in 2018, Competition Commission had carried out a study as well. Yes, it is not vibrant, it is not competitive, and globally, it's the other way actually. And you'll see that a lot of export is done from China, Thailand, Malaysia, Indonesia. Pakistan is lagging behind. What is the outcome? Because of the policies that are tweaked, we have given to the auto sector manufacturers a lot of protectionism. That is one thing which is again, which defeats competition. So when we talk about competition law and competition policy, I thought, and my understanding is that competition law means commitment to pro-competition principles and supporting all, all competition policy should be actually reinforcing the principles that competition law lays down. But it doesn't happen in Pakistan that way, like many other markets. So I would say that yes, I think there's a lot of protectionism being offered to many industries that needs to be taken away. And I think we need to do our policy advisory role has to be discharged in that respect. Try to understand that a lot of markets that are regulated, Competition Commission is not above the government. The Competition Commission can at best do advocacy and give policy notes, but where the enforcement is required, yes, then it can play its role in a different way. As far I would agree, Joe, I don't know what was the gentleman's name, but he did say that your deregulation thing was more of an aspect of competition policy and not competition law. I absolutely agree with that. And the third, when we are talking about cost of any product, and as Shaista said, that we are not here for fixing prices. We are only to check that. And if there is unreasonable price hike, that is where the role comes in. To be very honest, I didn't understand the comment. Was it a question or a comment? Because I didn't understand what was she trying to highlight. So if she can clarify.
I'll tell you what she was trying to say. Basically, the point is you are stepping on very dangerous territory. As an economist, I can tell you it's very hard to judge, and this is what came out in Microsoft and other cases, even AT&T. It's very hard to judge where market dominance and all these things you put in the law. I mean, it's very easy to put them in the law, but it's very hard to actually gain economic evidence in that. And I know many of my professors make a living out of this, like millions of dollars doing this stuff. It's very, very difficult to do. Here, unfortunately, and Qureshi Saab glossed over it, that it's very easy, we can hire the best expertise. There's no expertise available in the country, madam. There's no expertise available. So what we are doing is basically we are over-lawyering the case, that there are lawyers everywhere. Unfortunately, there's no economic analysis to back it up. I don't think you have the capacity to do the analysis. I don't think anybody has the capacity to do the analysis. And I have seen some of your studies, and I must confess, I don't want to get into the debate. Some of your studies, they don't hold water. And at the same time, you're giving judgments. For example, there's one study which says used vehicles should not be brought into the country. You have something on smuggled or whatever, but you say used vehicles should not be brought into the country. You're reinforcing the protection. The second thing is DRAP is a regulatory problem. It's a captured regulator. The protection policy is a captured regulator. In everywhere it's the government that is captured, what role does the Competition Commission have? The market doesn't exist in the country, so what do we do? That's the question. Bataiye.
Let's agree on one thing. Whether you are an economist or a lawyer, competition law, what matters is the fundamentals have to be right. And if your fundamentals are right, your findings cannot go wrong. You know, I had asked this question to consider to be the guru of competition law, that we are a nascent agency and we do not have in our orders much of economic analysis. What do you think our focus should be? He said, whether it's economics or it's law, if your fundamentals are right, you cannot go wrong. And I personally believe that if you look at all the decisions, our fundamentals have been rightly pointed out. Now, as for the studies, I don't know which one you are pointing out. I think auto sector ki 2018 ki hogi. But surprisingly, wherever we had done analysis, and I have to distinguish the time period, I'm sorry, because at that time we had a chief economist, we had economists as well. I don't think it's a question of over lawyering or having more economists. The competition agency mein hote hi lawyers or economists hai primarily, or chartered accountants also to assist and come to aid. Eventually, you have to make an agency robust with qualified people around. And how do you do that? You will not be able to do that unless you have financial autonomy. So you make that agency financially autonomous, you help it become robust, and only then you can have the resource which would aid in writing down all analysis that is needed. तो मेरा नहीं ख्याल कि हमें इस चीज पे बहस करनी चाहिए कि इकोनॉमिक्स की प्रेमिस क्या होती है, लॉ की. I mean, we can have a personal disagreements on that. Eventually आप ये देखें कि कानून जो enforce करना है उसका outcome क्या है, and it should be based on reason. If it's based on reasoning, it will stand the test of time. That's all you have to say. And I think अभी तक तो judicial review शुरू ही नहीं हुआ, जो हमारे जितने major cartels break हुए हैं. And eventually, if that comes, it will be a real signal to the market. I think it will actually restore the faith of the players as well. Last one thing I want to just add. ये एक concept बड़ा गलत है कि being pro competition is anti business. Somehow this has developed. I think pro competition means pro business. It's better for the businesses because a lot of businesses have approached competition authority कि उनके competitors, how they have been engaged in anti-competitive practices. I think we need to bring in this and promote this competition culture. We need to bring in corrective behavior. ये हमारा regulatory जो एक stance होता है ना, we need to be feared. I think more than that, we need to be respected. And I agree with you that respect would only come when you would have the right analysis and right reasoning to support your decisions. Thank you.
4 point. G.
Dr. Saab, can I make a few comments on this?
G, sure, go ahead.
Okay. I totally agree with Madam Rahat because she has a lot more experience, as being the chairperson. Two things, that I would like to highlight. First question was from the lady about how the commission, takes action. It is when a complaint is filed, or if they want to take a suo motu action, then there is an inquiry, and after the inquiry, they can do the search raids or dawn raids, search inspection or whatever, and then they find a report. They prepare a report with the recommendations, and the recommendations are considered by the competition commission, the whole commission in its meeting. And if they think, there is a substantial case, there that can go forward, then they allow the issuance of the show cause notice. The show cause notice with specific violations of the law has been issued. Then after the show cause notice, then there is a full-fledged hearing by the commission. In some cases, most of the time now there are 2 or more than 2 members. Then they hear the case and they pass the order. This is number one. The second question was, about the fixation of the prices, electricity prices. That has been happened, in France, and maybe Pakistan can also look into that example. In France, it's the same thing that is happening now in Pakistan, that there was even before doing anything, there was an agreement between the parties that this is the fixed price, and then on this fixed price, they will be giving the electricity, to the general public. And France now, what they have done is, now there is a bidding process. Then the power producers who produces power, they enter into bidding, or jinki bhi sabse lowest bidding the price hoti hai, then they get accepted by the government. So this is how the competition commission, and this is how, the stakeholders get the benefits. The other thing is, as you have yourself pointed out about the protectionism, Madam Rahat was very right. There is protectionism, and Shasta has rightly talked about a huge amount, involved in setting up of a auto vehicle, plant in Pakistan, and I think the best way is to allow the imports of vehicles in Pakistan. Let those imported vehicles, have more competition in Pakistan with the manufacturers. Now, another question, another comment that I want to make is, that is, we had earlier, passed an order, but that order was against the motor dealers association, they were involved in cartels and stuff. So we have passed an order and the case is pending in the courts, So as long as the cases are pending in the courts, what the commission can do is they can do their best, pass the orders, naming, blaming, shaming, making them guilty. The whole world should know, this is the wrong, that they're doing. But it is very important, for the courts to pass the orders and to have, this whole matter, settled. And the more importance, which has been given in the courts is, on the procedural issues, no one has said, not a single word, on the substantial law, that the abuse of dominance is not good, for example, or the trade or the cartels provisions are not good, or the merger control is not good, and there is something inherently wrong with it. Everything is good. So I think the courts have very important role to play. So this is my comment, on this.
Sadak Malik, the senator, wants to say something again. Senator Sahab, aaiye. Sadak?
Unmute myself. Okay.
Go ahead.
जी मैंने तो वैसे अपना हाथ नीचे कर दिया था. मैं यही कहना चाह रहा था कि एक तो ये कि I don't believe we have the capabilities that are necessary to appropriate economic damages or to assess economic damages, particularly with a focus on the damages appropriated to the end consumer through anti-competition practices. And I think that is a very nuanced area. It's not an easy area. It's not like I'm an economist and I can do it. I mean, I don't know of a lot of economists who can do it. The Lexicon is a company, Charles River Associates is a company, NIRA is a company. These are companies which have, people who specialize in figuring out the economic impact of anti-competitive practices, and they go and give testimonies in the court. And behind every testimony, there's a very detailed economic analysis, which I don't think can be carried out in Pakistan. So I thought it was unnecessary, but I thought since it was brought up, कि अगर principles ठीक हों, ऐसी कोई चीज़ नहीं. These are very detailed analyses that are carried out. तो दूसरी जो बात है वो आपने खुद ही जवाब भी दे दिया कि मैं कहने लगा था कि अभी आपने 2 मिनट पहले तो अपोज किया सेकंड हैंड कार्स की इंपोर्ट को, और फिर आप कह रहे हैं कि अगर इंपोर्ट की इजाज़त दी जाए तो फिर प्रेशर पड़ेगा automotive industry pay, and then they would either improve the quality of their vehicles so that people don't buy the imported second-hand cars, or they would decrease the prices so that people can get a new car for the same price as an imported car. And particularly with the devaluation, I think the entry barriers should be reduced, because we've tried this for 30-35 years and we've not been able to create, as you just mentioned, the value addition in terms of component manufacturing in Pakistan after 30 years. What doesn't happen in 10 doesn't happen in 1,000. So now you can go all on ad infinitum using the same argument that one day they'd never be manufacturing. The only way they'd be manufacturing is if there's competitive pressure, and they know if they don't locally manufacture at a lower cost point, they would not succeed, and the imported vehicles would wipe them out, the Chinese vehicles and the nanos and all those kinds of cars. So I think that was, since it was already kind of discussed, I lowered my hand. But I found it a very interesting conversation, and I hope towards the end of it, we do actually take some actions. And Nadeem, I sincerely make myself available for any deregulatory or anti-competitive. I do like the idea of competition law, because if you're going to deregulate the market, then some people are going to run away with the market, and we have to protect those who are less powerful. So only to that extent, I'm supportive of that. Thanks.
Thank you, Senator Saab. No, we'll take you up on that. Maliha, I think I must call you in, but please clarify for us, what is this competition that the law is talking about when you can't define it in economic terms? And as Musaddiq says, it's a very difficult thing, and as I told you, a number of my professors make a living out of this, but it's a very complex task. Microsoft spent billions of dollars putting up their case, and you know how it went. This is a very difficult. How is it that Competition Commission thinks it can do it? And then you also want to narrow it down to a legal thing. This is not a legal issue. It's an economic issue. How is it being transferred into law? And half of the economic issue is a captured government. What can the Competition Commission do against the captured?
So it's a very complex, I think it's been touched upon very nicely, and thank you for the excellent comments. And Nadeem Saab, I think it's a very complex issue and we cannot be simplistic about it. First of all, I'll have to say, because I personally set up the merger under, of course, the leadership of the chairman and with the help of my colleagues, the mergers and acquisitions review regime. And we took precedents and we took best practices of review from places like New Zealand and international best practices. And again, it was a very complex way of assessing the impact of a merger, because basically you have to ensure that the positives that a merger oftentimes tells you that, okay, perhaps when we merge, the scale will actually provide a lower cost and will actually make it a more efficient market, going into the free market and efficient productivity theory. It's very difficult to prove. And the dominance of obviously does become very easy to prove. Now, so it is a very complex issue. Does it require specialization? Does it require perhaps that you need to get technical expertise? And in my mind, at that time, I was a very much a proponent, and I was very supported by the chairman of getting technical expertise and collaborations with international antitrust agencies who have been doing this for ages, and having in-house teams which are not just financially well equipped, but also, yes, they also have the economic or the market cap. And we did feel that that was a very important aspect. Can lawyers do it? Well, yes, with the training, perhaps, yes, of course, anyone can do it. But is it right now easy to do? No, it's not. So yes, within and perhaps you see, I do, have to qualify that I'm talking about, quite a while ago when the commission was set up. So I'm sure Shaista will be able to tell us about what the current situation is. However, we did find that there was a certain level of expertise required. Your question and the question that has been coming up about the law itself, how complex it is, how difficult it is to understand, and whether we would require to simplify it and make it easier and more accessible to the common layperson. I would think yes. I think at that point in time, there was also an endeavor to do so, but the nuances of it, the fine, reading between the lines, I think that we still, the common layperson, or the undertaking, as Ikram Saab was saying, the undertaking or the person to which the law applies, they have to be able to understand it well. And by simplifying it, and by perhaps again it goes back into the advocacy and awareness kind of a domain, by simplifying it and making it very easy to understand, not only the undertakings and the consumers whose interests you want to protect, and the minority or the small shareholders who may, or the small companies, the SMEs, the micros, for whom you want to create a level playing field. Not only do they benefit, but also another, I would, and I say this with a lot of caution and with all humility. I do think that perhaps, by not being able to do this, we create a space where a lot of law firms step into that space and make the law a bit difficult to understand, or they make an opportunity for charging certain fees, which quite frankly are not necessary. And I want to give an example. When I was setting up this regime, I went to New Zealand for training, and I realized that they had, actually I went to Korea for training, I stand corrected, and I realized that one of my colleagues there was talking about how they had set up an acquisitions and mergers facilitation office. Now that's very similar to what Ms. Shaista was just talking about, facilitation through online facilitation, but at that time it was a physical office where they would help people apply for mergers, make the case for mergers, and then also expedite it. And we set that up with the blessings of the Chairman Saab. And that worked very well. But what it did create was, at that point in time, and we're talking about a long time ago, the average, we had reports and that lawyers and law firms were charging up to sometimes ₹1 million just for the application, just filling those forms and providing the documents. So what you're doing is by making the law such a mystery, and by making it so difficult for the common person or perhaps.
Let me make a comment, sir. I respect the opinion of Maliha Mimi Pankaj. My point is.
वैसे साहब जरा एक क्वेश्चन आ रहा है, क्वेश्चन जल्दी से ले लें, 2 सेकंड। अवैस साहब बताइए क्या कह रहे हैं आप? आपका पहला सवाल का जब मैं जवाब दे दूं, अवैस साहब वो बड़ा सिंपल है। We neither need a competition policy nor a competition commission. जी बताइए, markets are competitive, they don't need a policy. बताइए सब। Vesa, are you there or not?
And whatever your statement is, we don't agree with that.
No problem. I also do not agree. Respectfully, sir. What do you think is the alternative for this? You don't want the competition authority, so what do you want then instead of the competition authority?
Let the market.
You can please give us one example all around the world that instead of having a competition authority to bring in the market efficiency within the markets, and the sectors, they have something else, a new thing. You please let us know.
अच्छा जी, अब खत्म हो गया, चलें जी, we are all done. अच्छा, खालिद मिर्जा साहब कुछ कहना चाह रहे हैं? खालिद मिर्जा साहब, quickly, can you say a few words? He's here. Can you say a few words quickly? I think everybody's tired, so don't take too long. Khalid is there or not?
I have only one small little comment to make, sir. This is it, the last one on the market failure. It will take only 1 minute. Sir, I don't know how to put it. This market failure is a broader economic situation defined by the inefficient production, distribution of goods and services in the free market, And so one purpose of competition law is to enhance economic efficiency by forbidding anti-competitive behavior, And everyone has talked about those behaviors. Like if competition authorities can curb cartels, trade abuses, and stop anti-competitive mergers, the probability of enhancing market efficiency increases manifold, which will reduce the risk of market failure. But having said this, it cannot totally eliminate it, because market failure is actually related to the government policy and sectoral priorities. Indeed, the competition authority is mandated, and everyone has talked about it. So we are as Khalid Mirza Sahab used to say, hum to law ke putle hain. So we have a certain, limited action that we can take under the law, and rest is with the government and the sector regulators. They should, take up the responsibilities, and they should strengthen the hand of the Competition Commission and the commissioners, to achieve, whatever is the market efficiency through curbing the anti-competitive behavior. This is my comment.
Thank you. Avais Sahab, you want to say something? Jaldi boliye, time ho raha hai. यार unmute तो करें पहले. क्या चक्कर है भाई? हाँ जी बोलिए.
Yeah, thank you. They had actually disabled the unmuting button. नदीम साहब, आपका जो जवाब था, उसका मेरा जवाब उसका सिंपल ये है कि had economics been so realistic, we wouldn't have a rational economic man in the first place. We would have behavioral economics from the very beginning, which is not the case. So there will always be need in the real world. There will always be need of a policy. I do agree with the market-based, the economist's view of the demand and supply and all the market forces determining the demand and supply and the prices. I just raised my hand to actually offer my, क्योंकि यहाँ पे मैं ज़्यादा academics नहीं देख रहा. And what I've seen in my essay in Germany when I was doing my PhD in IP and competition law, and I came across a lot of competition academics there. What I do find is lacking is not the practitioners. We have the economists as well, But what I do find lacking is academics in the area of competition law, innovation, competition policy, innovation. Very importantly, आपने deregulation की बात की. बहुत मजे की बात ये है कि आज digital competition के अंदर regulation इतनी ज़्यादा नहीं है पाकिस्तान. But we still need some kind of, in all cases, intervention जहाँ पर digital products बेची जा रही हैं या नहीं बेची जा रही. दुनिया में हम देख रहे हैं कि यूरोप जो है वो यूरोप यूएस की कंपनीज को के खिलाफ $8 billion euros की फाइन लगा. But what I wanted to say is, I as an academic would like to offer, just like Malik Saab has offered in his capacity. So I would like to offer myself in my capacity as an academic.
Get in touch.
Yeah.
Get in.
So yeah.
Get in
and
touch
with everyone else too.
Okay, get in touch. We'll do it. You can get in touch with PID. We'll put you in touch, and inshallah we'll do it. Dekhi ji, I think Khalid Mirza's gone. I thought he raised his hand, but he's gone. I think. Is he here? Is he gone? Okay, I think he's gone. Acha ji, I think we've had a very good discussion. Absolutely correct. Let me quickly summarize what I'm trying to say. I'm just trying to make a very simple point, which I think we should all appreciate. This country has suffered because of too much bureaucracy and over-intervention. License Raj is still there, very much there. Government is protecting automobiles, government is protecting sugar, government is protecting textiles, government is protecting everything under the sun. DRAP, as you said, now I don't want to say anything irresponsible, but it seems like it's a captured body and somebody should study it. Same thing for many other bodies. It seems that we are captured in policy all the way through. That is why I think, and I maintain, and I think this has been maintained through a strong, let me go back to my old school, Chicago. We have a strong body of people there who say markets run themselves. They need neither a competition policy nor a competition law. Both of those lawyers make. Lawyers don't know how markets work. Lawyers, for example, Abhi Qureshi Sahab mentioned market failure. Now, I could go to town on that definition. That is an incorrect definition. Same thing as in the competition law, some of the 4 things that I see. As an economist, I could challenge those. But now the problem is the way you have set up the legal system. You guys don't even allow economists to testify. We can't even testify in the courts. Supreme Court says economists can't testify. They take all economics decisions without any testimony as well. The same thing on the Competition Commission. There is no testimony by economists. Economists can't talk. Not economists. The point is very simple. We've got loads of evidence that markets they work very well. They work very well. So let the markets work. Why can't we let the markets work? Why do you always have to have some ठेकेदार or थानेदार of the market? We don't need.
I am back.
सब आगे चले मिर्जा साहब बोलिए जल्दी.
हाँ जी, अब जितनी जल्दी कर सकूँ करूँगा. बूढ़ा हो गया हूँ, जरा थोड़ा सा तहम्मुल करें आप, आराम से थोड़ा. अच्छा, what I wanted to say was, first of all, you started off by talking about deregulation vis-a-vis competition.
Let me put it this way: the World Bank got it wrong.
Well, the World Bank may have got it wrong, and I don't frankly care whether they got it right or wrong. I'm just telling you that it's like apples and pears. Okay, deregulation is something quite different to what we are talking about when we talk about competition. Right. So, I mean, competition commissions, as I said in the last webinar, it operates within that area that the regulation doesn't exist. Now, there are reasons for regulations, and there are good reasons and bad reasons why you regulate. Okay, but I'm not going to go into that. And if I may say so, the law as it's constructed here for Pakistan, in Pakistan, the Competition Act, is a fairly simple and straightforward law. It's a direct law. The question is about its implementation. Now, you did mention that in Australia, they have this productivity commission, which was essentially focused on deregulation. And indeed, they did a lot of deregulation and did some very constructive work. But when it came to the competition agency in Australia, that wasn't touched by them. And the reason for that is very simple, because that agency operates within the market. If there is a market, to whatever extent that market exists, then you perhaps might need some kind of an agency to ensure that people adhere to the norms of the market, not regulate. Because the regulatory agency, this is not a regulatory agency. At best, it's a quasi-regulator, which is when it comes to mergers or when it comes to exemptions, then it does have certain rules which it follows. So let's make one thing very clear, that we are talking about an agency that is essentially operating within the context of a deregulation situation. Is not talking in terms of creating deregulation, nor is that its mandate. Okay. Now, basically, you're talking about a law enforcement agency that has certain violations. If they are done, it then acts against them. Some violations are pretty straightforward. You don't need much of an analysis there. Then there are other violations like the abuse of dominance, that whole area. A lot of that is also pretty straightforward. You don't need much of an analysis. Yes, there is a fringe area that you can analyze till the cows come home, and that's where we need experts like you, Nadeem, and others to help us. But that's a very small area. So we have to understand what is the scope. Do we need a competition commission in Pakistan? Given the fact that there is so much regulation, and given the fact that the whole area left open for the competition commission to operate is rather small, my answer would be yes, we probably don't. And what do we need here? I mean, one is to have when we go against regulation, then what are we talking about? We are talking about, let's say, the jungle, the laws of the jungle. And the jungle operates very well. It thrives. I mean, there is an ecology within the jungle, and it works very well. May not be too much progress, and there may be many fat cats even that die of starvation, but that's a different matter. The fact of the matter is the par for the course. You have a situation which is operative. You can have the same here, and it's extremely. I mean, has the Competition Commission done anything which is worthwhile? I'm not going to defend the Competition Commission. That's not what I'm trying to do here. The Competition Commission has done some good work. It's done some bad work. I can tell you some of its orders are questionable. Some of its policy notes are also questionable, even within the context in which they were issued. But then everyone makes mistakes, and everybody can have a different point of view also. But do we need a competition agency in Pakistan? The answer to that question is, do we need the market to operate? Do we need a level playing field in which economic agents can come together and transact business without being abused by one another? Do we need that, or do we not? We can perfectly operate without that. We can say that since it is too small anyway, since in any case everything is being controlled and everything is being, you have the whole business of regulation, if you like, then you may not need a competition commission, and I would go along with that. But if you think that this area which constitutes the market, if that is going to grow, okay, if you intend to deregulate, then you do need some kind of a competition agency. So the more you deregulate, actually, the more you need a competition agency. It's paradoxal, but it is true. I mean, the Competition Commission does not regulate. Let's be very clear on that point. All it says is, here is a law, this is a violation, and this is not a violation. It proceeds against the violations. And by proceeding against those violations, it tries to make sure that the whole market works. Does it succeed? I can tell you with my hand on my heart, nowhere in the world has the competition agency been successful. Nowhere in the world has the police been successful. Is Scotland Yard a success in England? I would say it's an abysmal failure. are the police agencies, are they a success in any country? The answer is a resounding no. They are not. But should they be there? Should they not be there? That's another question. And I'm now, everybody has been saying that you don't, or not everybody, but some of your participants have said, and I'm glad to see so many of my former colleagues participating here, Ma'am Rahat, Maliha, this Ikram Qureshi, and of course, Shaista, and all of them have said things which from their own light seem pretty sensible. Okay, but do we actually need to have a competition commission, given that even at its best, the contribution of the competition commission to the behavior of the market, to getting the market to work is so small. It's almost like the Titanic. I mean, if you've seen that movie, there's one shot in that movie in which the ship is very small. It's taken from up on high, and a voice comes out, "Is somebody there?" Now, this is a huge ship, the Titanic, but in the totality of things, it's actually nothing. And that's precisely the thoughts which comes to my mind when I look at the Competition Commission. It may be doing very good work. As I told you, I'm not here to defend it. And indeed, it has made mistakes, but that's not what I'm here for. I'm not here to hold anybody responsible for anything. But is this something we really need if we intend to deregulate and if we intend to grow the market? Do we not want the market to work? This is a very limited resource, a limited tool to get the market to work. And this is a tool, or this instrument, this institution has been very badly resourced. Okay, it has not received any support. I was the founder of this right up front. Okay, and for 3 years I was chairperson of this, and the government actually acted against it. What to talk of, supporting it? It actually withheld resources. Okay, but despite all that, by the grace of God, there was some progress that we made, however limited that had been. So much so that across the globe, in the competition network, international competition network, Pakistan was recognized as the rookie of the competition world from amongst underdeveloped countries. There were 2 other countries alongside Pakistan. One was Mauritius, and the other was a country which you know a little bit about, Egypt. Whatever little it has done in this area at that time, it was thus recognized. So now, should we build upon it? Should we not build upon this? That's a different question. If you're going to expect too much from it, then it's better to close it down, because we don't want it. Then let the law of the jungle prevail. Let people, and that's the free market. People can come and go, do what they like, no regulation at all. Somebody can buy a plot in the blue area in Islamabad and do oil drilling. That's fine. It's the free market. They can do what they want. No regulation is required. No, I'm not advocating regulation at all. I'm saying when you go towards deregulation, then you have to strengthen the competition agency in order to at least ensure that there is a semblance of order. There is a semblance of good behavior amongst with the agents that operate. No, hold your horses now. Just let me say what I have to say. Okay. Now that's one part. I know when some people get something in their mind and it sticks with them, they can't take it out. That's fine. I mean, I don't mind if you say that we don't need a competition agency. And then there is a lot of criticism, of course, of the previous agency, the MCA, which we had, which didn't do any work, which actually was given a bad name, not resourced, and they allowed it to fester, okay? And then they said it is no good. Actually, if you look at the law then, the Monopolies and Restrictive Trade Practices Ordinance, okay, there was a lot that you could have done with that too. And indeed, the 1 year that I was there, chairperson of that Monopoly Control Authority, I was able to do something. We were able to do something. So it's not, now, why is it that the Competition Commission carries such a bad press? Why is it that the Competition Commission is now not regarded as something worthwhile, not regarded as something worth having? And that comes to what was mentioned by Malia and so many others, advocacy. We have not been able to advocate what we are doing sensibly. Okay. We have not been able to actually, notwithstanding the fact that when Bill Kovacic came here, he's the all-time guru of competition law and policy for all times. Okay, and not only now, but ever since the whole antitrust business began, he is the guru. When he came here, he recognized two aspects of Pakistan, which he said the United States could actually learn something from us. One is advocacy, the way we were doing it. But that was then. What happened afterwards, I don't know. I mean, to what extent we actually did advocacy later, I didn't see much of it, at least not very effective advocacy. It was pointed out by Ma'am Rahat that advocacy works only if enforcement is there, then it is effective, which is true. That is the basic formula which I worked with. That is that you have advocacy, but in order to actually for it to be effective, in order for it to have any value, you had to have strong enforcement. And this is precisely the way in which we operated, and this is the way we were successful. And the Indians weren't. They started with advocacy first and enforcement later. The result is that their agencies is even less than half what we are. So we have that which we have to. Now, there are all kinds of cases, and I am not going to now say anything as to what case is good and what case is bad, and etc. etc. This is par for the course. The question is of the resources of this. Madam Shaista has mentioned that the 3% fee issue is under resolution. I hope she is right. I think if that is the case, then it is fine. But my guess personally is that the only way you can get the 3% is if you take the hardline approach, which is enforce this through your own provisions which you have, by which you can even sequester the accounts of these agencies in order to get this fee, and not only fee for this year, but for the past years as well. And there have been issues which have been raised here, which frankly I find them a little bit difficult to understand. I, for example, don't know what is the difference between controlling a price and fixing a price. What is not allowed under our law is any form of price fixation or any element thereof. And if there's any way in which we are trying to control prices, then I believe some elements are there of price fixation. And I think that is not, as was pointed out, this is the antithesis of competition, and perhaps it should not be there. Now, then there's the whole question of price increases, okay? Now, or fixing of prices as was mentioned. What the law states very clearly is that we can move against an unreasonable increase in price, not the price fixation. And the unreasonable increase in price is an open question that nobody has been able to actually answer. I remember I was in Geneva at this UNCTAD moot which they have on competition. And in that I raised this question because there they were talking of price fixation. And nobody was able to give a satisfactory answer. This is really something that even in our law, when you talk of unreasonable increase, the only unreasonable increase you can think of is if I'm giving, it's like discriminatory pricing. If I'm giving one price to one person and another price to another person and increasing that to that person to the second person, then that could be called an unreasonable increase in price. That's otherwise I don't see it at all. And unfortunately, there are some decisions of the Competition Commission that in fact talk in terms of and of somehow, you know, bringing in the whole concept of price fixation. Now, it was mentioned that the Competition Commission can only act against complaints from an undertaking as defined in the law. The Competition Commission can also act suo motu, which virtually means that if anybody can come to the Competition Commission with a complaint, the Commission can take suo motu notice of that and proceed. Now, I know you don't want me to say much about specifics, so let me finish here because I just wanted to say one or two things before I do that. That Pakistan has three basic challenges when it comes to implementation of competition law and policy: cultural, socio-political, and outright vicious opposition by vested interests. Now, just to deal with only one aspect, which is the cultural aspect, remember, we are here in Asia, and the outlook and approach in Asia, that is the Asian ethos, is remarkably feudal, despite the fact that large swathes of the Asian continent have been either under accommodation or have flirted shamelessly with competition, with socialism. Now, Asians are not fazed at all by abuse of dominance or collusive behavior or exploitation, and frankly, they're not worried about it, they're not concerned, albeit they would be extremely concerned if those with wealth and power are not charitable and generous towards the needy and the vulnerable. Now, that's the way the cookie crumbles in Asia. Robber barons are, generally speaking, acceptable in Asia as long as they are the giving sort. And we belong to this whole way of thinking, okay? So for the Competition Commission to act against people for collusive behavior, which it has to do, or to act against any form of exploitation, abuse of the dominance, whether it is exclusionary or exploitative, whatever we do, is not something that finds much favor or touches a chord with the general public. They're used to this. This is something which it's a part of life. It happens. So the challenge is very big. Of course, we know the political challenge and the socio-political challenge that I don't have need to repeat. I don't need to. And of course, there is this whole vicious opposition by opponents who have from the beginning tried to actually hit the competition area at two levels. One is they've tried to dilute the law. The other is they've tried to actually, if you like, weaken the commission. And one of the ways is by trying to populate it with people who are not acceptable or not the kind that should be there. Now, so what I'm trying to say here is only one thing, that this is a very limited tool. It's a very limited and that can operate within a very limited area in Pakistan. It will not achieve any fantastic objectives, okay? But if it is strengthened and if it is given the wherewithal, then in a very limited way and in a small way, it can produce worthwhile results. That's all I have to say for the moment.
Thank you very much. Thank you very much. That appeared like a good summing up. Anybody wants to say anything? We call it quite small. I think that's we've had a long session, good session. Look, I'll just say just 3 points in closing. One, nobody's against the competition. We have nothing against the Competition Commission. Competition Commission is a great organization. But I would say the World Bank got it. As always, the World Bank and the donors get it wrong. They make an agency before time, and the parliament is asleep. They don't care. The law comes to them, they pass it to the thinking. What we need is deregulation. We need the market first. You regulate a game which exists. There is no game. What is the Competition Commission doing? There's no market. And this thing to say that Competition Commission gets a bad press, no, that's wrong. No, there's no bad press. And then to say advocacy, quite frankly, we don't need a government agency for it. Advocacy should be left to the universities. Advocacy should be left to the people, to civil society organizations. No government agency, no donors should do advocacy. In fact, donors should be banned from. Second thing about the law of the general market, look, the market by definition is the law of the general market. Market works on its own. Thousands of studies have shown the market works on its own. In fact, market failure is very hard to prove. Cartelization is very hard to prove. And I worry about the fact that the Competition Commission sees too many cartels. I don't think that many cartels exist in this country. In fact, if you go back, I've just got an article in front of me of HBR article that's talking about antitrust law in the US. They can't find cartels in the US. They have been very, very lax in trying to find cartels.
Okay.
Whole issue the issue of market development is what we want to face. And we must face market development. Competition, as far as I'm concerned, this is only for the lawyers to make money. It's a great place for lawyers to make money. I know some lawyers who got very rich doing competition.
I respect your sentiments, but I have to say something. I respect what you said. As I said earlier, I agree with you. Finish it. Okay, right? No, that's not what I'm going to do. I'll just give you a little story. Okay, right? This is just a small little story, if you don't mind. And that is that here was this woodcutter living at the end of a jungle, and he had a very beautiful daughter. And lots of people wanted to marry her. Lots of young men wanted to marry her. Well, one day a lion appeared at the door of the hut, and the woodcutter came out. He said, "Well, I want to marry your maid, your daughter." He said, "Okay, I'll go inside and I'll ask her." And he came out and he said, "What I want you to do, the lady says she is prepared to marry you, as long as, you get your teeth removed, your fangs removed, okay, and your claws removed, right?" So the lion went back, came back, declawed, defanged, back, and then claimed the bride. Okay. So the woman came out. She gave him 2 kicks. She said, "Well, what I want you to do is to line up with all the other shooters and compete for my hand, right, on an equal basis, on an equal. Now, that is what competition law and policy is all about. But I totally respect your sentiment. Totally respect your sentiments. I mean, not for a moment do I disagree. I am just telling you what it is all about. Whether it succeeds or not is one thing. Whether it should be there or not is another thing. I'm all for the lion to have barged in, picked the woman up and taken her away. That's fine. Okay.
Thank you. Thank you. That note, let's end the conversation. We'll continue it again soon, inshallah. All the best. Thank you. Bye-bye.